I'm pleased to introduce Catherine Mozzie. Catherine is a partner at Mozzie & Tucker. She's board certified in family law. She is a former chairperson of the family law section of Travis County and has been licensed since 1993. I'm sorry, I had to say that.
I'll take it.
She's also one of my neighbors, so that's the other minor point. So Catherine's going to talk to us about child support.
Thank you. Good afternoon. I want to be probably about the 10th person to thank you all for being here, to thank you all for agreeing to take a VLS case. I recently had the honor of joining the board of the Volunteer Legal Services, and I've taken VLS cases for many, many years. I've been doing part of this presentation for 5 or 10 years now, and I can't stress to you all, even more so now that I'm on the board, how important it is that all of you are here and all of you are participating. The need is overwhelming in our community. So many people simply can't afford to access legal services. And without volunteers like everybody in this room, those people's needs would largely go unserved. I will also tell you that I've practiced law for a lot longer than Shane gave me credit for, which is fine. I don't need to be any older than I am. But the most fulfilling experiences I have ever had, have been with my VLS clients. You know, if you had time someday and we were having a glass of wine or a beer, I could regale you with some stories. But suffice to say, I know that I have made the work I did on behalf of my clients made a huge difference in their lives. I can think of a couple of people that would have lost their homes, probably would be homeless today, but for the fact that they were able to come to VLS and able to get someone to agree to represent them on a pro bono basis so that their rights could be protected. And the issues we're dealing with in VLS cases are often issues of homelessness, of somebody being safe, some of the most fundamental and basic issues that clients face. So again, I want to thank you for being here and agreeing to take a case. And with that said, I bet several other people have told you, if you take one of these cases and you have questions, please feel free to call. I'm happy to take a call from any of you if you have questions as you're working through your case. So give a call, give an email, and we'll try to help you. I'm here today talking about child support. Usually I would give the first in the morning speech about basic procedures, which felt to me a lot like an initial consult that I had with my clients. I could just run you through what to expect. This year I'm talking about child support, and even though every year I say I'll write a paper, like a lot of lawyers, I won't say most, I'm probably a procrastinator, so I have just edited a little bit the really good paper that Kevin Dietz wrote in 2012 about child support. He has probably a lot more case sites and information than you would have seen if I'd written the paper myself, so I encourage you to take a look at that. So, child support is governed by chapter 154 of the Texas Family Code. The purpose of child support is to help a child's standard of living be maintained at the level of his or her parents. Child support is basically set on a guideline. Somebody who makes minimum wage is going to pay a lot less child support than some of my private practice clients who are doctors or lawyers or somebody who has a high income. And that makes sense. Again, the purpose, the philosophy behind the way the legislature set up child support is to make sure that kids have a standard of living that is somewhat pegged to what their parents have. Now, only parents can be ordered to pay child support. So you might be involved in cases in which a grandparent or another relative has had custody and maybe you're representing the parents and perhaps the other relative is going to get some possession. But only a parent can be ordered to pay child support. And when you go to court in a family law case and an obligor is ordered to pay child support, they're also going to be ordered to pay medical support. And that includes health insurance for children. Your order is going to require that there be a provision for how the uninsured medical for the children, that is what's not covered by insurance, is paid and allocated between the parents. Typically that's a 50-50 basis, but again, if you have a wide disparity in income, as you might in a VLS case, your VLS client has met some income requirements, so they are not going to have a lot of money. But the person on the other side of your lawsuit, be it a divorce or a SAPSR that I know you've already heard about, especially when folks aren't married and just have a child together, could have a wildly different income. In that kind of circumstance, think about asking the court not to do a typical 50-50 division of the uninsured medical, but to do a disproportionate division. I just settled a case last week where we said dad had to pay 75% of the uninsured medical and mom only pays 25% because his income was so much greater. So, child support is payable for children who are before the court until they turn 18 or graduate from high school, whichever is later. You might have a child who was ill and had to sit out of school, or you might have a child that was held back in school and doesn't graduate until that child's 19 or 20. Child support is payable until that child graduates from high school, assuming they're attending high school. It's also payable until a child marries. So if you have a case and the 16 or 17-year-old gets the parents' permission to marry, the obligor no longer has to pay. Or if a child is given permission to join the armed services before they turn 18, then child support would cease as well. If you have a case in which there's a child with disabilities, child support can be ordered for a disabled child upon the appropriate proof of the disability indefinitely. So way beyond the child's 18th birthday, as long as the parents are alive in the appropriate circumstance. If a child or a parent, if a parent is receiving Social Security disability payments, that the Social Security Administration will make payments to the child for the parent or for the parent receiving Social Security. But if you have a child who is him or herself receiving Social Security disability insurance, you need to be careful because the child support you have arranged to have ordered in the divorce decree or in the SAPSR could reduce the child's Social Security disability payments. There is a reference in the paper on page 10 to this issue. There's also a reference to a paper Keith Maples wrote and presented several years ago about special needs trust. That's a little bit beyond the scope of what we can talk about today. But if you have a situation like that, be sure and look at the paper and then grab Keith Maples' paper that talks about the need for special needs trust. All right. So how do we go about setting child support? I've already told you it's set on depending on how much money the obligor, the parent paying child support, makes. You need to look at section 154.062 of the Texas Family Code. That defines what we look at to set child support. We look at the obligor's net resources, which includes all the wages, salaries, compensation for personal services, which includes commissions, bonus, and overtime that the obligor is receiving. Be sure and look and make sure that the obligor, are they working overtime? Have they received a bonus during the year? If they have, you should include that in your calculation. Don't look at just one paycheck. Try to get a year-to-date view. It also includes, net resources include interest, dividend, or royalty income, or net rental income. So if you have a case where the obligor, for example, is a landlord, has several pieces of property, you're going to have to look at probably tax returns and figure out what net rental income that person is receiving. And that money can be used to set child support. Net resources also include severance, retirement payments, pensions, annuities, capital gains, unemployment payments, disability and workers' comp payments. So you've got to look and make sure that you're capturing all the resources, the net resources that the obligor has. The Family Code says we can include deemed income in an obligor's net resources. That means the court could impute income to assets that aren't currently producing income or that have been voluntarily transferred to somebody else. And I can promise you more than once in my practice, I've seen a situation in which someone has, for example, a piece of property and says, I'm just going to give it to my brother, my mother, my uncle, so that I don't have that income from the property to count as my child support in calculating my child support. If you have a SAPSR or a paternity case, you're going to be able to get retroactive child support for your client if you plead it, and that's an important point. If you don't plead it, you're not going to get it. So let's say you have a case in which you're establishing paternity for your client. The child is 5 years old. Plead retroactive child support. You're likely to get support set from the time the child was born. So how do we calculate child support once we figure out what somebody's net resources are? You're going to look at the Office Attorney General tax charts, which are contained in the Family Code and probably in the materials you've been given today. The charts basically take somebody's gross monthly income and they subtract from that Social Security payments, federal income tax withholding for a single person claiming one deduction, and Medicare. And why did I stress the federal income tax withholding? Because lots of people will claim more deductions than they're actually entitled to, so that more tax is taken out of their check during the year so that they get a big payment at the end of the year, or maybe because they just don't realize what they're doing. The Family Code says we're not going to do that. We're not going to look at what somebody's actually receiving. We're going to just look at their gross and figure out what is called their statutory net. And that's what you're going to calculate child support on. Now, in looking at the Attorney General tax charts, it's important to recognize that there are two different tax charts. One is for employed persons and one is for self-employed persons. The reason for that is if you're self-employed, if any of you are, you probably know this, you pay double the amount of Social Security tax. If you're employed by someone else, the employee pays half the tax and the employer pays the other half of the tax. So it's important to distinguish when you're setting support, is the obligor self-employed or employed by somebody else? Once you get your statutorily defined net resources, and again, it's not what somebody actually takes home. What I often tell my clients is we did away with that a long time ago because back in the day, some guy would, or woman, would show up and say, Judge, I can't pay child support. I've got this Ferrari payment. I just don't have any money left at the end of the day. We don't care. It doesn't really matter what the obligor's expenses are in almost all cases. We just have this formula that we look at, gross, and from that gross we get a statutorily defined net. From that statutorily defined net, it depends on how many kids you have before the court, what the child support is. For one child, it's 20% of your statutory net. For two, 25%. For 3 children, 30%. For 4 children, 35%. There are often, and more do I see in my practice, situations in which an obligor may have an obligation to support children in more than one household, right? So there's 2 baby mamas, and you've got the one dad obligor who's got to pay for 2 different kids in 2 different households. The legislature has decided it's not fair to the obligor to say he pays 20% for kid in household A and 20% for kid in household B. And instead we have a chart that you can, I think it's based on a mathematical formula. I've never been able to figure it out, so I just look at the chart. That's in Family Code section 154.129. I know, for example, if there's one child before the court and there's another child for whom the obligor has the duty to support, whether that be paying support in another household or the obligor is remarried and has a child in his or her household that he has an obligation or she has an obligation to support. In that situation, the obligor is going to pay for your client who has only one child 17% versus 20% if there were just the one child. So the guidelines max out at annual gross wages of $141,000 a year. It's about $11,000 and some odd a month. So you may not have a lot of VLS cases with that kind of income, but I have. You'd be surprised. If you have somebody that makes up to that much, $120,000, $130,000 a year, and they work, for example, for the city, for the state, for a corporation where they just get a set amount of money every month, that's just math, and that's pretty easy. In the very odd VLS situation in which you might have an obligor who makes, for example, $300,000 or $400,000 a year, the court is able to go above the guidelines. I should say the guidelines, the statutorily defined net resources under the guidelines max out at $8,550 per month. And that equates to $1,710, I think, for one child, somewhere right around there. For 2, it's $2,250. If you have, again, an obligor who makes a whole lot more money than the top of the guidelines, don't be afraid to ask for above guideline child support. There's a specific section of the code that deals with that, and what it tells you is that what you do is you have to calculate the child's proven needs. That means you got to make a budget, not just for your client and the household, but set aside, break out what the child needs to live. Take part of the housing expense and attribute it to the child, a half, a third, whatever seems reasonable. Take part of your client's car expense and insurance, car insurance expense. Come up with a number that is the child's proven needs. And this again goes back to lifestyle. And the example I often give in my office is, if you got a case where you have somebody who, your client, the obligee, works for minimum wage, but the obligor is a professional sports player who makes $1 million, $2 million a year. The kid's standard of living should be somewhat pegged to that obligor standard of living. That person makes so much more than the guidelines that you need to ask for more than guideline child support. So after you figure, for above guideline child support, after you figure the child's proven needs, which is going to be a fact question, and it's going to require you to gather your evidence and present it persuasively to the court, you subtract from that amount the guideline child support, and the court is then to allocate the difference between guideline child support and the child's proven needs between the parents according to their ability to pay. So in my example of a professional sports player, they're going to have a lot more ability to pay that extra $1,000 a month in the child's needs than the minimum wage obligee, the mother. In this, what's probably more likely to happen in your VLS cases is you're going to have an obligor who makes just minimum wage. The family code has a presumption that child support should be set at a minimum based on minimum wage. Minimum wage is right now $7.25 an hour. That works out to gross wages of $1,256 a month, annualized at $15,000 a year. It's not very much money. When you do the math according to the Attorney General tax charge that I've been talking about, if you have one child, guideline child support works out to be $224, $225 a month. It's not very much. But if you don't have, again, if you have an obligor who makes very little money or doesn't have a job, you can rely on that. Another important section to note is that the family code says if you have an obligor who is intentionally unemployed or underemployed, the court can set support based on what the court finds that person ought to be making. I've had that come up in more than one of my VLS cases as well. You have, let's say the mother is supposed to be paying support, and she comes in and she says, "Judge, I can't pay anything. I don't have a job." Well, do a little investigation. Gather your evidence. What if this person has a vocational degree, a college degree? What if you know that in the past, this mother who's supposed to be paying support used to make $40,000 or $50,000 a year? Bring that evidence forward to the court and ask the court to set support based on what you know the obligor has previously made or ought to be making. The court, there's a case that's cited in the paper called Iliff versus Iliff. It's a Supreme Court, Texas Supreme Court 2011 decision. And it says that in figuring whether a parent, an obligor, is intentionally unemployed or underemployed, the court can consider a variety of factors. They include a parent's general right to pursue happiness, whether or not the parent is attempting to avoid or reduce child support, the desire to spend more time or live closer to a child, start a new business, pursue education, the prevailing economic conditions, and diligence in pursuing employment. So the obligor's intent is going to be important. One of the court can also consider various other factors in deviating from the guidelines. One of those could be the cost an obligor incurs in visiting with his or her child. Let's say mama has primary custody of the children and lives here in Austin, and that dad, for example, is in the military and is stationed in El Paso. It's pretty difficult. You can't get here for dinner on Thursday nights. It's going to be pretty difficult to drive, 600 miles 800 miles, back and forth from El Paso to Austin. So there may be some expense in traveling, maybe some expense to fly the child out there. The court can consider those factors in setting child support. The court can also consider special needs of the child in deviating from the guidelines. So you have a child who might not be disabled in the sense that you can get child support to go on forever. Like if you had an autistic child who is never going to be able to live independently. But you may have a child who has severe dyslexia or is in need of special educational resources. The court could consider that in going above the guidelines. The court can consider the age of the child and the needs of the child. That's particularly important when you have an infant. When you're in court and there's a 6-month-old baby, and daycare for a baby is really expensive, and that's going to be several years before a child is in public school and kindergarten. So the mother, the person having primary custody, is going to have additional expenses to keep the child in daycare. Consider that and ask the court to, for a certain period of time, raise the obligor's child support above what would be just guideline support. I've already talked about medical support, and so in addition to providing direct child support, the Family Code dictates that the court shall order medical support. That means health insurance. And starting in September of 2018, the legislature said this year that we're now going to require dental insurance. I think it's really odd. I've never seen a statute where they do that prospectively so many years in advance, but that's coming up in 2018. Many of your VLS clients are not going to have insurance available to them. The world has changed a bit since we've had the Affordable Care Act, but we've had for several years something called CHIP, Children's Health Insurance Program, in which, at least in the past, minimum wage people, VLS type clients could go and get really affordable child health insurance, $20, $30, $40 a month, depending on their income. But you need to be sure and make provisions for that. It's typical that if the obligor has insurance available to him or her through their job, that they're required to put the child on and provide that family coverage. You get to consider the cost of the health insurance when you come up with your statutorily defined net resources. The cost of the health insurance is deducted from the gross wages we get to the statutorily defined net, which means that an obligor doesn't get a dollar for dollar reduction in their child support for the cost of health insurance. For example, the cost of health insurance is $100 a month to the obligor. That's deducted from the gross wages along with the Social Security, Medicare, federal income tax withholding to get the statutory net, which means the obligor is then going to pay 20% of that statutory net. They're not getting a dollar for dollar reduction for the cost of the health insurance, the way that math works out. The Family Code also says that if insurance is not available to the obligor, your client, the obligee, could be ordered to put the child on his or her health insurance if they have it through their employment, and then the obligor is required to reimburse the actual cost of that health insurance. When you're looking at health insurance, often there's family plans. So the way it usually works is there's one cost to add children. 1 child, 2 children, 5 children. Be careful if you're representing the person receiving support to make sure that if the obligor has other children he or she is obligated to support and must provide health insurance for them, don't put the entire cost of that child coverage. What you would do, for example, is if it costs $100 a month for the obligor to maintain family coverage on his or her health insurance, and that person has an obligation to support 4 children, only attribute $25 to the child that's in your case, for whom you're setting support. And that's kind of a little trick that a lot of people don't realize, and it can make a difference of, $10, $20, $30, $50 a month to your client, and that could be the difference between whether they have enough to pay the electric bill that month. Another thing that's come up and is different in the practice recently over the last 5 or 10 years is more and more people are doing a 50-50 possession schedule with children. There is no statute in the Family Code that addresses what we do when parents have a 50-50 possession schedule. Judges are starting to order it more and more. I would have said 5 years ago that that's just totally unusual and you never see it. I see it a lot now. I think that's a testament mostly to men who have decided they want to be more involved parents, and parents are equally sharing parenting responsibilities. So what do you do if you have a 50-50 schedule? Well, let's back up and say, if somebody has just a regular standard possession schedule with their child, if you mapped it out, and I've done it before, because I had a case where my client didn't want to pay child support. And we talked about a 50-50 schedule versus a standard possession order. Depending on how the holidays fall in a certain year, a standard possession order gives the non-primary parent 40 to 45% of the time of a year with a child. And if a parent has a standard possession order, they are presumed to pay child support. So now we're getting into the realm of 50-50 possession schedules more and more often. You're going to hear, well, I shouldn't pay support. I have that child 50% of the time. That may be right, it may not. Again, there's no statute. I will tell you the way lawyers like Shane and I settle these cases, and the way I see judges doing it more and more often. I know of a case just this week when a judge ordered child support this way. What you do is you look at the higher wage earner's income. Let's say in this case it's the obligor. Let's say, to make up round numbers because I'm bad at math, that the obligor makes $8,000 a month. Your client, the obligee, makes $3,000 a month. 8,000 minus 3,000, the difference is 5,000. Set your support based on the difference between what the obligor makes and what the obligee makes. Again, courts are doing it more and more often. Now, if the obligor and your client make about the same amount of money, if they are both minimum wage earners and they've agreed to, or the court orders, a 50-50 possession schedule, it may very well be fair to say no direct child support. But you really need to look at that to make sure that your client and the child living with your client is getting the support they're really justly entitled to. In many of your VLS cases, you may run into a situation where you're taking a default. You show up, you're ready, you've got your budget form that I bet somebody's already talked about, at least it's required under the Travis County local rules, which on the front page shows how much money you filled out for your client, how much money your client makes. The second and third pages are a budget. What does it cost to run the household? The opposing party, the obligor, is required to do the same thing. The local rules also say you're supposed to attach the last pay stub so that we can look and see, are they really telling us the truth about how much money they make? But the obligor doesn't show up. You're going to take a default. You're entitled to take a default for your client. But it's really important that if you take a default for child support, you put on some evidence. The case can be reversed on appeal if there is no evidence in the record about how much money the obligor makes and where you've come up with that child support figure. It's enough to have your client take the stand and say, well, when I lived with him, I know he worked at the city of Austin and he was making $35,000 a year, or whatever the case may be. Just be sure you put on some evidence when you're taking a default. So we talked about the budget form that's required. You also are, in course, entitled to do discovery, just like in any other sort of civil lawsuit. You can send a request for production. You saying, give me your bank statements, give me your pay stubs, give me your tax return so I can look and see if you really make what you're telling me, or if all of a sudden your income has gone down the month I filed this lawsuit. Don't be afraid to use those tools. Don't be afraid to send a business records affidavit to the employer and say, send me the wage information for this client. So remember, if you're doing a business records affidavit, it has to be on file 14 days before you go to trial. So that may or may not work for a temporary orders hearing. And of course, the good old-fashioned way, if you've got a case and you've got an opposing counsel, ask them to voluntarily provide you information for their client. What kind of income does their client make? Let me back up and talk about self-employed folks again. Self-employed folks have lots of easy ways to hide their income. Those folks you have to look at more carefully. I had a case several years ago where we had a trial, and he said, I don't make any money. I've got this insurance agency. I don't make any money at all. I had his tax documents. I had done discovery. Well, guess what? He had a $1,000 a month car payment. And guess what? The judge said that's really not a legitimate business expense and put that $1,000 back into his income to calculate it. You're going to also, when you get your order entered, be sure you enter an income withholding order. And that's going to allow the obligor's employer to take the income out of the obligor's check before it passes their hot little hand. You're going to set up an account with the State Disbursement Unit. That's the Office of the Attorney General. They will keep a record of all the child support payments that have been made. It is really important that you do that. If you do that and you later on there hasn't been child support paid and you're in a position of having to do an enforcement and the payments have gone through or not gone through the State Disbursement Unit, you get a certified copy of that record, and that's your proof about how much support has been paid. You can all, if time permits and you're going for a final order, child support and temporary orders haven't been paid, file a motion for enforcement. Child support is the only debt in this country that we allow somebody to be in prison for. Courts take it seriously, and the person who's ordered to pay child support and doesn't can really get in trouble. But because we might conceivably take away someone's liberty for not paying this debt, you have to plead very specifically. Also, that means your child support orders need to be written very specifically. They need to say exactly how much is to be paid, on exactly what date, to whom. Failure to have that kind of specificity in your order could result in your not being able to enforce it. Are you standing up because I'm done? Huh?
No, I just.
Okay, I didn't know. All right. Okay. So if somebody is behind in their child support, do file that enforcement action. It's important to note that if you file an enforcement action and you're successful, the obligor didn't adhere to the earlier order, whether that be an earlier SAPSER order that's a final order, whether that be a temporary order you got in this particular case, and you're successful, the court will award attorney's fees. Don't be afraid to ask for them just because it's a VLS case. It would be nice if you ask for them and they're awarded, that you donated those to VLS so that we could have even more resources to represent these folks, but they're awardable, and don't be afraid to ask for them. Child support that's not paid on time accrues interest. Any child support payment that is 30 days or more late automatically accrues interest, and the current rate is 6%. Important to note that if the obligor files bankruptcy, his child support obligation is not discharged, any arrearage is not discharged, and you are not prevented from going forward to collect it or to establish it. The bankruptcy code was changed, I think, in 2005 to say we don't even have to go file a motion to lift automatic stays. Most of you are aware, once somebody files bankruptcy, all bets are off. You can't litigate, right? Somebody can't sue you for your credit card bill, can't foreclose on your house until they go to the bankruptcy court. Not true for child support. So even if you get a suggestion of bankruptcy or a notice that bankruptcy has been filed, go ahead and establish and collect your child support. If your case is only a protective order, you can get child support established in the protective order. Don't be afraid to do it. Your client may need it. And finally, when you're doing a divorce decree or a SAPSER, you're often going to get questions about the IRS dependency exemption. Parents of children are able to claim the dependency exemption for the child. You need to know that that's not anything that the state court can do or award. That's a federal law, federal statute. So don't ask a judge to award a dependency exemption, because he or she's going to tell you they simply can't. The IRS rules are that the parent who has the child the majority of the time is entitled to the dependency exemption. There are times that I horse trade or I have a 50-50 possession schedule, which again is happening more and more. And so you might decide that it's fair that the parents alternate from year to year, even to odd year, the dependency exemption. You can make any agreement with your clients about the dependency exemption, but just know that you can't ask the court to order it, because that's beyond the divorce court, the state court's jurisdiction. So that is an overview of child support. I'm happy to answer any questions if anybody has any. Yes, sir.
So are parents obligated to pay the child support for college education?
Good question. No, they're not. The state court can't order it. The court only has jurisdiction over the children until they turn 18 or graduate from high school. Once they're 18, the court can't even enforce a possession order or make a new possession order, but can require the parents to support the child after they're 18. But once they go to college, you can try to get an agreement, and I often do. If you get an agreement and you put it in the order and it's drafted the right way, it can be a contract and could be enforced if it's not paid, just like a contract. But the court will not order the payment of college tuition, college expenses. Yes, sir.
How
how does bankruptcy affect if the governor is in bankruptcy? How does that affect child support?
It shouldn't affect it at all. You're still going to go to the state court and go through the same scenario that I've been describing. What does he make? How much does he make? What are the gross wages? And I don't think, no, the court, I don't know, maybe the court would consider that he has court-mandated bankruptcy payments. I suspect not. It's still going to apply the percentage, 20%, 25, or whatever the percentage might be of his statutorily defined net resources. Yes, ma'am.
I have a couple of questions. The first one is, when you're doing a divorce, you're getting like a VLS divorce. Is
Uh-huh.
it possible that you'll have someone coming to you looking for a divorce who already has a child support order in place with like an estranged spouse or something? And then the other question is, you mentioned that you can get child support indefinitely for a child with a disability. When that child, because I guess it depends on the disability, right? When the child turns 18, assuming it's not a cognitive disability that requires some kind of a guardian in light of like guardianship or something, who enforces the child support order if the parent is not complying? It's like, say I'm the child, right, or what I was the child, I'm 21 now, and my father was ordered to pay indefinitely, but he's not doing it. Who goes to enforce that?
Well, if the child is over 18 and doesn't have any cognitive disabilities, has some sort of physical disabilities, I would see no reason why the child couldn't do it in his or her own name. Of course, if the child is cognitively impaired, then the parent who is receiving the child support or the guardian, I found a lot of VLS cases you might have a situation where there isn't a formal guardianship. And yes, you can have a divorce in which you file it and there's a pre-existing child support order. It could be because there's an existing protective order that ordered that. It could be because these people were married, but before filing a divorce, they had a SAPSR filed and child support was established then. So yeah, that happens. And that's why it's important when you plead, I'm sure somebody earlier in the day talked to you about this, when you draft your divorce pleading, it's going to say there are or there are not any other orders affecting this child or these children that are before the court in your case. Because if there are, the court needs to know about that, and it's going to have to be considered in the new orders that are made in the divorce. Anybody else? Okay. Thank you. Thank you all again.
So our next speaker, I'm going to say her last name not quite right, but I will try. Katie Vale, she is the family law staff attorney for Volunteer Legal Services, and she formerly worked at Legal Aid of Northwest Texas. She's going to talk with you about the 5 most common issues you will face in VLS cases.
Good afternoon. I want to thank all of you for being here today. I'm Katie Valle. I'm the family law staff attorney. And when you volunteer for your family law cases, please always feel free to contact me with any questions that you have. I work for VLS. I'm here to help you guys. And my cards are up at the table up there. If you haven't already gotten one, please feel free to grab one on the way out. You can always call me or email me, whatever you prefer. I'm good with either. I'm going to, I want to thank, first of all, Doug Lawrence. I used his paper from previous years. He's my successor he's my predecessor at VLS. And I also based my presentation on his, so I want to thank him for letting me use that. I'm going to real quickly go through a couple of the 5 things listed. I want to save plenty of time for the family violence presentation because many of you will probably have cases with elements of family violence, and that's hugely important in our cases. So the first thing I'm going to hit on, and what I'm going to hit on the most, just because I get the most questions about it from new volunteers, and it's going to be the original petition. That's obviously important, especially for those of you who haven't handled family law cases before, because that's your first leap into it, is that petition. And so it can be really scary, but it's not that scary, I promise. And again, I'm there to help you. And we have amazing mentors through VLS that can answer any questions you have as well. Many of them have spoken today and are very willing to help anyone with any questions. So first thing to know about family law petitions is you don't, in family law we have notice pleadings, which basically means you just have to kind of notice the other side of what you're asking for. You don't have to plead evidentiary facts underlying your requests. In other words, you don't need to go into specifics in your petition. You don't need to list out all your evidence in your petition for the most part to support what you're asking for. You're going to do that in court. You're going to do that at the hearing. The petition is not the place to do it. Generally, as the first speakers this morning said, your petitions really, especially in VLS cases, should be like 3 pages, 3 to 5 pages. If you have a petition and you've worked on it and it's more than 5 pages, let's go over it before you file it, because chances are you may have overpled a little bit. You will have all the forms that you need on the thumb drive that you guys got today, for those of you who are volunteering for the cases. And there is a master petition on that thumb drive. It is 25 pages, but that's because we've included every contingency, and under each subheading we've included all the options. You then would go through after your initial interview with your client and kind of erase what doesn't apply, take out requests that you're not going to ask for, things like that. I can give you examples also of petitions we've done before, that I've done before, even the pro se petitions, if you want to kind of see it in finality. I'm going to go specifically right now over 14 things that you will need to include in your petition for divorce. The first being the grounds for your divorce. In Texas, we have no fault and fault grounds. In your petitions, I would encourage you always to plead no fault. Always. Specifically, insupportability. Insupportability basically says, it's allowed in Texas. It says we're not going to get along, we're not getting along, our marriage isn't working, and we're not going to reconcile. In addition to no fault grounds, you can plead both. You can also plead fault grounds. I would say to be careful in our cases to include fault grounds. It depends on your case. Just because you have the ability to plead a fault ground doesn't mean you should. I would encourage you to look at what is the benefit pleading this ground is going to provide to my client before you decide to include it. Sometimes if you plead fault grounds and you have a party that maybe wouldn't have even responded, and then you prove these fault grounds, you're going to get a response for you might not have before. If there's no property and no children, you're really going to be fine with insupportability, with a no fault ground. Your client may be ready to, she may be or he may be very angry and wants to include everything in the book in your petition. But again, I would encourage you to just advise her that, look, this may not benefit you. It's horrible what's happened to you. You're right, it's not fair, but it may not benefit you. It may hurt you in the long run to include these grounds, especially again, if you don't think the other side's going to answer with just pleading insupportability. Talking about fault grounds, though, that you might include in a VLS case, the first one is going to be cruelty. Cruelty is a ground that you would plead if there's been family violence. The reason you would include grounds if you have children or if you have property is because these grounds, and especially family violence falling under cruelty, can affect the division of the community estate. Courts can and do award a disproportionate share when there has been family violence that has occurred. Additionally, family violence and cruelty can affect orders as to the children as well. So if it's applicable in your case, if there are kids and some property, I would say cruelty may be a good ground to include. If you're going to include a ground, you need to be able to prove it in a hearing. So don't just say cruelty and then not be able to present any evidence on it later. Don't just throw them all in there just because and hope that maybe you have something when you finally go to court. Find out first if you can prove it before you include it as a ground for divorce. Another ground that, again, sometimes is included is adultery. This really isn't going to affect, for the most part, orders in relation to children. This ground primarily affects a property division, as abandonment is a similar ground. So if you have no property, I just don't know that you'd want to include adultery in these petitions. You might get a fight where you otherwise wouldn't. So again, what grounds you include as far as fault grounds goes has to do with your individual client and how you think that's going to help her case and how it's going to help her get what she wants in her final decree. The next thing that you always have to plead, number 2, in your petition is your discovery level. There's discovery level 1, 2, and 3. We, for the most part, for pretty much all cases, I feel comfortable I can say all cases, VLS cases, are going to be level 1 or level 2. We really just don't have the estates for a level 3 discovery. If there's no kids and no property, feel free to plead level 1. I generally, just out of practice, plead level 2 all the time. Why this is relevant is because it affects the amount of discovery you're able to do throughout your case. So you don't want to plead level 1 and then realize later, oh, there's more here than I thought, but I can't do the discovery I want. I should have pled level 2. It's not going to hurt you to plead level 2. Again, unless you have no kids, no property, then you might be able to do level 1. But for the most part, in VLS cases, the most property you're going to have that you're going to be in charge of dividing, if there's anything really, is going to be a homestead, maybe a car, maybe each party has a car, and maybe sometimes retirement. While we're talking about retirement, one thing to keep in mind while you're deciding which case you want to pick for VLS is if there is a retirement and there's a possibility that it might be divided, you will have to do a quadro. It's called a Qualified Domestic Relations Order. That will need to be part of your final documents when you finalize the divorce. So just a note, keep that in mind. If you don't think that a quadro is something you're prepared to do or want to learn how to do, I wouldn't take a case with any kind of retirement pension or anything like that. So just keep that in mind. The third thing you're going to need to include in your pleading and your petition is the type of service you're wanting to get on the respondent. You can look up service in Texas Rules Civil Procedure Rule 106. That applies in family law cases too. It's one of the most important issues we face in VLS cases actually is getting the other side served. Personal service is the best. That's the best way to go. If you get personal service, you can go to court and say, yes, Your Honor, I know for a fact that the respondent has notice of this suit. And if they didn't file an answer, you're going to have the best luck getting your default judgment that way. In your petition, the way that would look is respondent John Doe should be served at this address. And one thing I've learned over the years as far as assisting you later, if for some reason he's not or she's not going to be at that address, is include a little phrase at the end of that says, or wherever he may be found, or wherever she may be found. We are really lucky in Travis County. Precinct 5 Constable 5 is amazing. They are great. They work very well for VLS volunteers. They're wonderful. I encourage you to contact them if you ever have any questions. And you actually, when you request personal service, you'll request them specifically if you're serving in Travis County. But sometimes your respondent may not be in Travis County. They may not be in the state of Texas. They may be in other places. And in some places, if you list only an address and then you figure out later, oh wait, he's not there. He's not at his mom's house at this address. He's staying at his sister's house 2 doors down, and you call the constable and let him know, they're going to say, well, that's not the address you included in your petition, so I'm sorry, I can't serve him there. And then you're going to have to replead. I've had luck getting past that when I've included the phrase, or wherever he or she may be found. Home is often best place to serve if you have that address. Work is fine, but really anywhere you can find the person, then it's up to the respondent to file an answer and provide the court with his address of record. If you do not have an address for the respondent, and when I say you don't have an address, I don't mean your client saying, well, I don't know, I don't really know where he is, and then stopping there. Don't stop there. You need to ask your client, well, who would know where he lives? What about his family? What about your friends that you had in common when you were together? What about where he was living the last time you saw him? What about where his relatives here live? Is he staying with any friends? I would encourage you to look online. If you still, after searching for him and having your client really search for him, if you don't know where he is, you have the option of publication. If you have no kids, no property, you could actually do service by posting. However, if you have kids or you have property or you're asking for a judgment or anything like that, you're going to have to go with service by publication. For either posting or publication, again, you're going to request that in your petition. And for either of them, you're going to have to attach an affidavit to your petition explaining why it is you're asking for this form of service, why it is you can't personally serve them, and you should be detailed. And you should explain, if you've done a search, which you should do a search, exactly what you did. We checked with friends and family. My client called his mom. She refused to give the address, or she didn't know where it was. the respondent was deported and we don't know where they were deported to. We check the Texas Department of Criminal Justice, Google them, social media, appraisal records actually can be helpful, check public data, everything like this. And you should do this search yourself, and you should put that in your affidavit, everything you did. The reason why that's important is because if you go to court to finalize a divorce and you've received service by publication or posting, and you just said in an affidavit, I don't know where he is, it's not going to work out very well for you. You're going to be sent away, you're going to have to do a search, and the judge is going to want to know about it. So just avoid the embarrassment. Do the search in the first place, put it all in the affidavit, and go with that. Especially in publication cases, because in publication cases, there's going to be an attorney ad litem that gets appointed to your case, and their job is to find respondent. So if you haven't done a good job in trying to find respondent yourself, you better believe that attorney ad litem is going to find the respondent. We have great attorney ad litems here in Travis County. We have great attorney ad litems at VLS. They will find respondent if respondent can be found. So you might as well do it yourself and save yourself the time and trouble and your client of going through, waiting for the attorney ad litem to do all the work, waiting till you get to finalization just to find out, oh, wait, never mind, we're going to have to start this over again. So if you're thinking about publication, I just really encourage you, exhaust your resources, think hard about any way you could find them, do whatever you think. If you have any questions or want ideas, call me. I'm happy to provide them. I'm also happy to review your affidavit, if you like, before your client signs it. If you are going to publish, if you've done your search and you know you can't find him and the attorney ad litem has said, well, I can't find him or her, then check with me, because your next step will be, if you do want to publish, you've got to get a VLS publication memo, and that will waive the fees of the publication. However, we only have 4 publications available each month for free. So, and they go quickly, because we have a lot of cases where publication is the only option. So please check with me before you request the publication to be sent over to the Chronicle, because if we're out that month, it could cost several $100s or a lot of time from someone from our agency to work with them to try to get that extra publication waived. But just check with me. If we have the availability that month, I'll sign you up right away. I'll get you that memo immediately. If not, you'll just have to wait till the next month. Another service option that keeps coming up more and more is foreign service. This is when you know where the opposing party is, but that opposing party is in another country. For our VLS cases, this happens a lot in Mexico and Central America. We're also seeing that the judges are kind of changing what they want in cases where foreign service is an option. One thing you need to do is see if the country where the respondent is located is a party to the Hague Convention. That lays out how people have to be served when the country is a party to the Hague Convention. Again, I'm not going to go into this in a lot of detail, but contact me if you're starting to have issues with foreign service. Another option for service, for example, let's say you have an address here in Travis County for respondent. You sent the constable out, the constable's tried to serve 3 or 4 times, Precinct 5 did it, so you know you've got a great affidavit that's been sent back if they couldn't serve respondent. And so here you are, no service, you know this person's here. What do you do? Because you can't publish on them because you know they're here. So one option is you'd file a motion for substituted or alternative service. And again, that's listed out in Rule 106. Contact me if you have any questions. An example of that would be, requesting that notice and citation be allowed to be, posted on that door or handed to somebody at that residence. Those are the various options. Yes?
Are there any special requirements or obligations with those in the military service?
Yes, there are, and I can talk with you about that one-on-one, or if y'all have a case where that is involved, because it's very different. So I want to go through this today, but yes, the answer is yes. That's a great question. And if that applies to one of y'all's cases, let's talk about it one-on-one. There could be a whole CLE just on that. Yeah. Okay. The fourth issue you always need to plead in your petition is children. You would need to plead any children that were born during the marriage and are children of the marriage. You need to also plead any children that were born during the marriage but are not the biological children of the husband. This happens frequently in VLS cases because a lot of our clients have been separated from their spouse for 5, 10, sometimes 15 or 20 years for varying reasons. Sometimes they were scared of the courts, didn't know what would happen. Sometimes they had no idea, this happens a lot, that they could even get divorced without their spouse's permission. Or they just didn't realize that there was a no-cost option. These are people that are very near poverty, so getting a divorce, paying an attorney to get a divorce from someone who's far away and not bothering them isn't necessarily on their financial priority list. Food and shelter beat that by a lot. So by the time they get to us, sometimes it's been a while. Sometimes they have a new partner and they have children together. So you'll need to plead all of that in the petition. If the child is born during the marriage, that child is presumed to be a child of the husband. So part of what you're going to have to do through the process is put in place a case and an order that excludes the presumed father, i.e. the husband, as the father of that child. On the thumb drive, Doug Lawrence, again, did a great list, a great sheet of step-by-step what you need to do to get that done. I'm not going to go through that right now because it is written out in the form on your thumb drive. But again, this can be kind of complicated and scary for people who haven't done it before, so please call me. I'm happy to help you out in any way that I can. One thing you will have to know, though, if they're in Travis County, one thing you're going to need to do if that is the case is you're going to have to get the biological father served, because the court isn't going to make any orders or have any findings towards regarding the biological father if that person hasn't been served in the lawsuit. Like I said, a lot of times that's mom's current partner. You might get that person just to sign a waiver. If husband and father are both present and things are fairly amicable, maybe they, with the mother, could go fill out an acknowledgement and denial of paternity. That is the best way to do it, if you have that option. Unfortunately, that's not going to be an option in many of our cases. But just know that if there's an alleged biological father, we're going to have to get that person served one way or another. Again, something else you will plead in your petition in regards to the children of the marriage that are the husband's children. You're going to have to plead what you want to happen in regards to conservatorship, possession, child support, things like that. It's pretty straightforward, although that sounds like that's going to be pages and pages, because for a lot of people that's the most important part of the divorce. It's not. Again, the original petition is pretty straightforward. You don't need to plead evidentiary facts here for the most part. If there's family violence, there's a paragraph specifically in the master form that you have addressing that. If you want to request joint managing conservatorship, you say that. Sole managing conservatorship, you say that. You basically are just going to say, we're requesting the court make orders as to conservatorship, child support, visitation that are in the best interest of the child. What you will need to note in the petition under that section is if, again, like I said, family violence, there's a paragraph on family violence, include it. If there's a disabled child or an adult disabled child, you'll need to note that in the petition as well. And another thing, and there was a question on this earlier, if there is an existing order as to any children, you'll need to state that in the petition as well. If there's an existing order as to the children, that's what we call a court of continuing jurisdiction. What that means is, in Texas, when there is a court that's made orders as to children, that court retains jurisdiction over further orders regarding those children unless and until that case is transferred out of that court. In Travis County, you can file, if there is a underlying SAPSR, a suit affecting the parent-child relationship, an order in a SAPSR, you can file the divorce under that cause number. If the children in the SAPSR are the same children you're addressing in the divorce. If the children in the SAPSR are completely different children than the children in the divorce, they don't go together. They're not the same case, they're not the same kids. That's going to be a brand new case, different kids, they wouldn't go together. If the SAPSR order is out of a different county or a different state, talk to me. We can do that. but it's just a couple more steps. You have to transfer that case here and then consolidate them. And we can do that. Don't worry, we can do that, and I can walk you through that if that case arises for you. I'm not going to do it now because I'm trying to save a little time for family violence. Retroactive child support, it was stated earlier by Catherine. If you're going to request it, you need to plead it. It is one line. It basically says petitioner requests the court order retroactive child support. That's in the master petition too. It's in accordance with Texas Family Code 154.131, protective order, in accordance with Texas Family Code 6.405. If there is a protective order, you must say so in the petition. I would include the cause number and the court from which it was issued, and I would also attach it as an exhibit to the petition. A lot of times, if you get a case where the opposing side, if there's a history of family violence and there's a protective order, the other side is not, sometimes they're not going to list the protective order. So if your client says there's a protective order, you get a petition from the other side that says there's not one, find it. And prepare your counter petition and state that there is a protective order. Another thing you'll need to plead is if your client is requesting that certain property is his or her separate property. You can actually plead this specifically or generally. You can plead it generally by just asking the court to identify certain property as your client's separate property, as separate from the community estate, or you can state that and then list the property specifically. It's up to you. Another request you'll have to make in your petition is that the court divide the community estate. Again, that's very easy. There's language that says the parties will come to an agreement. If they don't, then the court should divide it, or you can just straight up and ask the court to divide it. I would do that. It's usually easier, and in a lot of our cases, you may not get an agreement. You may not have a party you're ever going to get on the other side, so just asking the court to divide it is fine. Most of your cases, again, though, will really only have personal effects. So when you get to, when it comes time to preparing your final order, it's just going to say basically he keeps hers, she keeps his, or she keeps hers, he keeps his. So that part can be relatively simple, especially in our cases. Another request you will have to make is in regards to family information being included in the decree. Pursuant to Texas Family Code 105.006 and 105.007, certain information about the parties must be included in a final order. This becomes an issue when there's family violence, specifically if she's fled the violence and the abuser does not know where she lives. You're obviously not going to want to include her residential information in an order so that he can get it. So in order to keep that information out in your original petition, you're going to have to request or plead that it be excluded from the final order. Again, it's just a paragraph. It's already in the master petition. Just if you're dealing with a case in family violence, that's something that's very important to a lot of our clients and affects their safety and the safety of children directly. So that's very important. If you want to include permanent injunctions, this is important, especially when there's protective orders, because protective orders are only good for 2 years for the most part. But the injunctions included in protective orders are really great, sometimes for much longer than 2 years. I have literally just copy and pasted some of the prohibitions from the protective order into my original petition, asking that they be permanent injunctions. And they're granted, and they last much longer than a protective order. But if you don't request permanent injunctions specifically in your petition, the ones you want, you're not going to get them in the final order. They have to be included. Name change. A name change must be also included in the petition if you want to get it. Sometimes our clients don't want to change their name at the beginning because they want to keep their name the same as their children's, and then you get to the final hearing or the prove-up and they say, oh, no, I want to change my name. Unfortunately, that's not going to happen. You have to plead that in the petition in order for her to change her name. In that situation, she's going to have to finalize her divorce and then go change her name on her own. So definitely go over that with her. If she says, no, I don't want to change my name, just let her know. If we don't plead it, you can't do it later. You can't change your mind in this divorce. Finally, the prayer. A lot of people leave that out from what I've seen in petitions, but you need to, basically it's the last paragraph in your petition. You're requesting requesting the court grant the relief in your petition, you need to go ahead and include that in. Finally, there's a couple forms that you need to include with your petition. Civil case cover sheet should be prepared and filed with your petition. The Travis County standing order should be attached to your petition and filed, as should be the health insurance form that's required. It says right in the petition, health insurance information required by whatever section of the family code. And there's a form on your thumb drive that it's basically lists the kid's name and check what kind of health insurance they have. For most of you, it's going to be Medicaid or CHIP. But you do need to include that. I don't always include a request for temporary orders in my original petition. I don't if there's no property or no kids. The standing order actually covers a lot of issues you'd otherwise need through temporary orders, and the standing orders are enforceable. So before you decide if you want to go forward on temporary orders, if you think the other party may not contest or respond, look at your standing orders, see if there's something else you want. If you have children and you need child support, or there's a danger there or family violence, then you should definitely ask for temporary orders. But absent children, absent family violence, it's not necessarily a necessity in your original petition. And keep in mind, you can always later file a motion for temporary orders if you change your mind and decide that you want them. Mediation, I'm going to go through this real quickly because I'm out of time. But we have volunteer mediators, so if you get to that point and you realize, okay, it's time for mediation, call me, let me know. I'll hook you up with a half-day mediator. For a deposition, to be honest, our cases really don't need them almost all of the time. Of course, there's exceptions to every rule, so if you happen to get the case where a deposition is necessary for the protection of your client and her interests, then we can work with you to find a pro bono person that can assist with that. The last thing I'm going to say is while you're preparing your petition, you should be looking at what you want in your final decree. Figure out what you want at the end when you're deciding what to plead in the beginning. That's the best advice I've ever gotten. If you don't know what you want at the end, you haven't done enough research yet, and you're not ready to do your petition. Sometimes, especially, I think new attorneys will prepare their petition without even thinking about where this is going to go or what they want at the end. If you look at where you want to be in the end and base the beginning on that, you're going to have a great petition and you're going to get covered whatever it is you want to get covered. Again, if you need anything else, I'm Katie Valle. I'm at VLS, so please feel free to contact me, and thank you all so much for your time. If you have questions, just email me or call me. I'm going to move on so we can get enough time for our family violence speaker because we're a little bit behind, but thank you all so much for your time.
Our final speaker is Gina Lungwitz. She is the, oh, okay, that wasn't my imagination. She's the professor and director of the University of Texas Domestic Violence Clinic. She has been awarded the Texas Law Fellows Excellence in Public Interest Award. She has trained numerous current family law attorneys here. Some of whom are here, and Gina frankly knows more about protective orders and domestic violence than anybody I know. And so I'm going to turn it over to her. And
wow, I'm going to remember that the next time we're in court. I'm just going to say, remember what you said. Just a second. All right. Thank you so much. Nothing says the holidays like the poinsettias, the tree, and the Divorce Basics seminar. I want to thank Anna K. Myers and Steve Elliott. They put a ton of work into this, and I also want to thank each of you who are going to take a pro bono case. It says a lot about you. Based on the backlog and the wait list at my office, there are a lot of people who need help, and I want to just say thank you for those of you who are taking on some pro bono cases. Just in case you're like I am and you get to the end of a long CLE day where you've gotten a lot of information, I'm going to kind of tell you what I'm going to cover just in case you want to, make your shopping list or your grocery list or that sort of thing. The first thing I want to talk about is a lot of times when I am speaking, I will use the term she for victim and he for perpetrator. That's really to keep things short, so I'm not saying perpetrator and victim over and over and over again. Statistically, that's typically what you're going to see, but it's not always what you're going to see. There are cases where you have female perpetrators and male victims, and we also have same gender relationships that are abusive. So I just want to throw that out there to let you know that. The first thing I'm going to talk a little bit about is screening for domestic violence. How do you know that your client is a victim of domestic violence? I'm also going to talk a little bit about safety planning. That was something that was new to me when I started practicing law, and people started throwing that word around, and I didn't know what they were talking about, so I'm going to talk a little bit about that. And then finally, I am going to go through the typical legal options that come into play when there's violence in the relationship. I'm following the paper that you have on your thumb drive, just so you know, if you're somebody who likes to follow along. And the paper is much more detailed than I'm going to be. So just know that there is a reference point there. So before jumping into the remedies, how do we know? Somebody walks in our office, they say they want a divorce. How do we know that they're experiencing violence in their home from an intimate partner? And why is it important for me to know? Why do I have to know, or should I know, if they aren't going to just blurt it right out and tell me? Well, the first reason is an ethical reason. It's impossible for us as lawyers to provide our clients with the legal remedies available to them, the menu as I call it, unless we know what the situation is. So to avoid malpractice and grievances, that's one reason we want to know. But another reason is safety. Not only safety for our clients, but also safety for their children and safety for our offices, safety for everybody. So that's another reason. Now, clients aren't always going to self-report this. And there are a million reasons that could be its own talk about why people don't self-report. But I venture to say that if I said to this crowd, how many people here are crime victims? Not domestic violence crime victims necessarily, but crime victims. Raise your hand. I bet not everybody in here would raise their hand. But I bet if I ask, has anybody here ever had your car broken into, your wallet stolen, your phone taken? I bet we would get almost every hand in here raised. And the same is true for victims of domestic violence. Some people don't think of themselves as victims. But if you say, has your partner ever pushed you, slapped you, held you down, taken away your car keys, that sort of thing, you're probably going to get a lot better picture of what the relationship is like. So you will notice that attached to the paper is Appendix A, and that is the form we use in our office. It's a form that I have people circle yes and no. Are any of these things true in your relationship? And it tells you a lot about the dynamic that's in that relationship. And so that can be used to spur further communication. If they answer yes to a question, oh, I see that you say he's pushed you. Tell me about that. And that can get you more information. So the bottom line is we want to ask more specific questions, not just is there family violence, domestic violence in your relationship? So finding out things like who controls the money, that sort of things, those can also be telltale signs in violent relationship. So let's say we've done that, we've had them fill out that form, we learned, oh, there is abuse in this relationship. Well, what do we do with that information? So the first thing we want to do is we want to do some safety planning with them, and I'm going to talk more about what that is. But another thing that's really important is to find out whether it's okay to reveal that information to the other side, because it's not always. Sometimes people have been threatened with their lives. They don't want it brought up as part of their divorce. We don't have to bring it up as part of their divorce, but we need to know whether it's okay with them that we have a conversation with the other side about that. And what we know about violent relationships is the most dangerous time for a victim of domestic violence is when she leaves that relationship. That is the time when she's most likely to be killed, and it's also might be the time when she's contacting VLS to get help with a divorce. So that's important to know. So now we've interviewed, we found out, we know they're a victim. How do we do safety planning? There's nothing real, it's not rocket science, this safety planning business. All it is having a real practical conversation with the client about how they're going to stay safe. So helping them think through common sense things they can do, like gather together the birth certificates, the social security cards, the financial information, you know, income tax returns, bank statements, pack a bag that has extra, maybe a little extra money in it if they have any access to money, essentials for children, an extra set of car keys, those sorts of things, and put that bag somewhere so that if they have to leave quickly, that they'll have access to it. A lot of times that's with a friend. Sometimes maybe they're employed and they have a place at work they can keep it, that sort of thing. So you want to help them think through that. Or maybe they're separated at the time. So, you know, do they walk out of work alone? Do they have people who can walk with them? Did the kids run to the door every time the doorbell rings and throw it open? You know, have they talked to their kids about let's not open the door when the doorbell rings, that sort of thing. So attached to the paper as Appendix B, you will see a safety plan, and you will notice there is no copyright on it. You can make it your own, put your own law firm logo on it. It's something that will help you talk to people about being safe and help them have something they can walk away from their office and give them some things to think about to stay safe. And then finally, the last attachment on your paper, Appendix C, is what we call the skeletons in the closet sheet. Like most of us, our clients are not perfect. They've made mistakes along the way, and you can bet that their soon-to-be ex is going to want to remind them of that throughout this process. So it's really nice to find that out before your client's on the stand. It's good to know, what are my bad facts? Does my client have a substance abuse problem? Has CPS been called on my client before? That kind of thing. Because when you find out when they're on the stand, there's sometimes not anything you can do about it. But if you find out early, you might be able to address some of those problems with them before you get too far along. So this is a form that's going to help you do that. All right. So what I'm going to move on to now, in an effort to stay on time, are the legal options. I wonder if it would make sense. I don't know if it's possible just to get the front lights turned off. Somebody knows it's possible. All right. Well, we're going to talk through these. They just told me how to do this. Let's see. Let's help this thing on now. All right. So this is just a list of what I call the usual suspects. These are the usual legal things that come into play when someone is in a violent relationship. You may have a case that has other things that come into play, but these are the usual ones. I'm going to talk through each of them, spending more time on some than others. I'm not going to spend a whole lot of time on the criminal complaint, simply because we aren't going to be prosecuting the crimes in these cases. The paper goes into a little more detail about that. But there are just a couple things that I want to say. The most popular domestic violence crimes, the ones that you'll hear over and over when clients come in the office, are what we all think of, the assault. That's usually kind of an obvious one. There's also something called the terroristic threat. The elements of that are in your paper. Interference with child custody. A lot of people don't know that it is a felony in the state of Texas to take off with a child in violation of a court order. That's important for my clients to know, both because I don't want them being charged with a felony, and also because we want them to know that they can call law enforcement if somebody takes off with a child. We'll talk a little bit more about that in a minute. Harassment, stalking. If there's a protective order in place and somebody violates it, they can call the police about that. Interference with an emergency call. In Texas, if I'm trying to call the police and you run and you grab my phone out of my hand and flush it down the toilet, that happens a lot. There's a class on that or something. If that happens, that in itself is a crime, interference with an emergency call. And then there's kind of a newish one called continuance violence against the family. This is section 25.11 of the Penal Code, and if within 12 months somebody assaults a family member causing bodily injury twice, then they can be charged with continuous violence against the family. As I said at the beginning, I'm not going to spend a lot of time on the a criminal complaint. Sometimes clients don't know that it's an assault if their spouse assaults them. They think, oh, well, but we're married. I hear that every once in a while. I'm always surprised now that it's 2015 and we hear that, but we still do hear that sometimes. So it's important to tell people one legal option you have is to report that to the police. I want to say just a couple things about interference with child custody. There are 3 different ways someone can commit this crime. The one that you hear about most often is in the left column. If somebody takes or retains a child knowing that they are in violation of a court order. So if it says, you know, you've got to bring the child back on Wednesday and you don't bring the child back on Wednesday, then it's possible somebody could be charged with a crime. I will tell you the reality of it is we could have our own police force that all they did was enforce these kind of possession schedules. So typically police are not going to be very interested in pursuing it unless a few things are true. Sometimes if there's a protective order in place, you will get them very interested. Sometimes if people are crossing state or national boundaries, they'll get interested. So I think it's good to tell your clients they can report it, but they shouldn't expect magic or people to jump to action necessarily in those situations. Another way is if there's a pending lawsuit involving the child and somebody takes the child, runs off with the child, and stays gone for 3 or more days, then that's another way somebody can interfere with child custody. And then finally is what I call the Disneyland parent situation, where somebody tells the 16-year-old, you come live with me, I'll get you a car. That sort of thing. The non-custodial parent enticing the child to leave. So I just want to throw those out there so that you're aware of them. Some important things to note about protective order violations. I think it's not going to let me do it. All right, just a couple things to note about protective order violations. If a law enforcement officer actually sees somebody violating the order, the arrest is mandatory. Why is this important? Because people reconcile. And you may have situations where somebody has a protective order against somebody else and they reconcile, and the applicant in the protective order, the victim, may invite the respondent over to her house. It's important, if you represent the perpetrator, to tell them, if law enforcement sees you there, you will be arrested. There's no discretion in that. And you may think, that's crazy. Why would that be? Well, the reason I can tell you, just because I've been doing this long enough, because I remember when that passed. And the reason why that is often, no matter what happened, no matter whether the respondent was invited or not, they would say that they were. And then the police are like, what do? We have somebody who's invited over, and they've been invited. So now the judges here in Travis County are usually pretty clear in telling people at the end of a protective order hearing, if a protective order is issued, that they can't agree not to have the protective order anymore. In order for the protective order to go away, it either has to expire by its natural, by the date that it says it will expire, or they have to come back to court and ask that that be modified. And people do that sometimes, ask that it either be vacated or modified so there's no stay away, that sort of thing. The second thing to note is that a person protected by a protective order cannot be arrested for violating it. They simply aren't ordered not to do things, so they can't be in violation of it. So that's important to note. Every once in a while you'll get a call from somebody who said, well, the police came and told me they were going to arrest me next time I called, or something like that. That's important to know. And then finally, sometimes in protective orders it will have the address of the residence that someone has to stay away from, and sometimes it won't. If it doesn't have the address, it's still enforceable. The reason for that, the Texas legislature just determined that if somebody's within 200 yards of somebody's house, there's a reason that they're there usually. So that's important to know. You don't have to put, like Katie was talking about, you don't have to put the address in the order. So just a couple things. Texas is a big hunting and gun rights state, and because of that, I mean, I've been in more than one protective order hearing where somebody says, does this mean I don't get to go deer hunting? To which Judge Denton responded, only if you want to go to the penitentiary. So, something to know about firearms is that if someone has been convicted of a Class A misdemeanor family violence assault, they cannot possess a firearm until they have been out of jail or off probation for 5 years, whichever comes last. Or maybe they were never charged with any crime, but they have a protective order against them. If you have a protective order against you, you can't possess firearms or ammunition. If you do, it's a Class A misdemeanor. There isn't a Texas exception for full-time law enforcement, but you will not find this exception in the federal law. There's a federal law that mirrors, actually I think Texas law mirrors the federal law, but not quite. So just know that your client, if they have a protective order against them, they can't possess a firearm. And now in Travis County, there's language we regularly put in protective orders telling them how to surrender those firearms. Because, you know, you're in court, you suddenly have an order saying you can't have a firearm, but there's one at your house, so what are you going to do? Well, now orders are telling people what they need to do, which is turn them over to the Travis County Sheriff's Office. All right, that is all I'm going to say about criminal stuff. And I'm happy to stay after at the end if people have questions. So if you remember that very first list of things, there was the criminal complaint. The second thing was the magistrate's order for emergency protection. I'm not going to spend a ton of time on this either because you are not going to be going and getting these on behalf of your clients. This is something that happens when someone gets arrested, and chances are you will not, you won't know this has happened until an order is already in place. The purpose of this is to protect victims after someone's arrested for family violence, stalking, or sexual assault, but before they can get down to the courthouse and request a protective order. This is like a gap. This is to fill the gap between that time. So who can request one? The victim, the victim's guardian if they have a guardian, the peace officer, the prosecutor, the magistrate. The reality is how it works here in Travis County is it is almost always the magistrate who is sua sponte issuing these orders, and they can do that. And sometimes you'll have a law enforcement officer there, but the truth is the victim doesn't even know when somebody's being magistrated. You know, it happens fairly quickly here in Travis. So somebody goes to jail, and then they go in front of a magistrate, usually pretty quickly, and that's when the bond is set and all that sort of thing, and that's when these can be issued. The victim doesn't have to be present. In fact, I know of not one single case where they were present, and it can be issued without the consent of the victim. So this isn't something that your client has necessarily even wants, but sometimes one will be in place. So who can these be issued against? Someone arrested for family violence, someone arrested for stalking, someone arrested for sexual assault. Those are the three different scenarios you may see where someone has a magistrate's order of emergency protection. When can it be requested? And there are people who will debate me on this, but I think I'm right. At the defendant's initial appearance before a magistrate after an arrest for family violence, sexual assault, or stalking. So there's a very limited window of when someone can obtain this relief. Yes?
And so, family violence, that specifically means that they're married or have children, is that not, that doesn't include just domestic violence?
That's a very good question. In just a second, when I get to the protective orders, I'm going to talk about all the ways, all the different relationships but that's a great question because it seems like they add a new relationship every legislative session. So what do you have to prove for a magistrate's order? Essentially nothing is the short answer. The arrest means that there was probable cause to believe that someone has committed whatever crime, and because of that, there's no like real burden of proof for that. The issuance of the magistrate's order is mandatory if there's been serious bodily injury or if a deadly weapon was used. So what can it do? These are the main things that it does. Prohibit further acts of family violence, sexual assault, or stalking. It prohibits communication between the victim and the perpetrator. It prohibits someone from going within a certain distance of the victim's home, the work, the school, the daycare, and it suspends any license to carry a concealed weapon. So what if your client has an order, let's say in a divorce, they're already divorced, they have an order that says, Dad can come to Mom's house the first, third, and fifth Friday of the month at 6 p.m. and pick up the kids. And then subsequent to that, a magistrate's order of emergency protection is issued that says Dad can't come within 200 yards of the house. Which order governs? The short answer to that is the last order governs. The only exception to that is something you're probably never going to see, but I do throw it in. If the magistrate's order says one thing and a temporary ex parte protective order issued later says something else, the magistrate's order is still in effect unless the temporary ex parte order specifically has language in it saying that it supersedes the magistrate's order. So how long are these in effect? These aren't very long orders. I guess they are long if you're, depends on your perspective, I guess, but 91 days is going to be the longest. It's 31 to 91 days, and it depends on the situation. If there's serious bodily injury, it can be longer. If a weapon was used, it can be longer. When I say longer than 31 days. They used to just be 31-day orders, and now there's some variance. But the context in which you are likely to see these is when your client comes in. This happens sometimes. The client will come in and say, hey, I have a protective order, so I'll go on the Travis County website and look for the protective order, and I don't see anything. Well, what they mean is a magistrate's order of emergency protection. Sometimes they don't mean that they've been to the county attorney's office and gotten a protective order, or a private lawyer has assisted them, or they've done it themselves. Sometimes it's these magistrate's orders. So you probably just want to get them to bring you a copy, and it will be pretty obvious. All right, that's all I'm going to say about those, because that's probably all you need to know about those. All right. Sorry, I guess I am going to say, what happens if it's violated? Arrest. First offense is a Class A misdemeanor, up to 1 year in jail, up to a $4,000 fine. Second offense is a state jail felony, which is 6 months in jail, up to 6 months and a $10,000 fine. I am going to spend some time on protective orders, and the reason for that is we will never know how many lives they save, but I know that they save lives. I was just looking at statistics from 2014, domestic violence homicides in Texas. Travis County had 2. Harris County had 23. Although Travis County is smaller than Harris County, we aren't 10 times smaller than Harris County. And we have more protective orders granted here, and people in this community take it seriously. And I attribute protective orders and our response here to that. So I want to say a little bit about protective orders, because this is something that if a client comes in, our county attorney's office does the vast majority of protective orders here, but sometimes if you're representing a client, something happens while the divorce is pending, you could do it as well. So I like to talk about them. So why get a protective order? Because we have these, I'm sure somebody talked about the Travis County standing order that's a restraining order against both parties saying don't behave badly, essentially. Well, there are really 2 big differences. The first difference only law nerds care about, and that is the intent of the law. The intent of restraining orders is to protect property, so that I don't build a fence on your property, or I don't, take money out of the business until we've decided how to divide that up, that sort of thing. The intent of the protective order law is to protect people, to protect lives. The second difference is the difference that our clients care about and that we as lawyers typically care about, and that is how they're enforced. If you have a restraining order against me that says I can't come within 200 yards of you, and I come within 200 yards of you and you call the police are probably going to ask me to leave, but they aren't going to arrest me for that because it's a restraining order. It's a civil court order. But you could go get a lawyer, you could file a motion for contempt for me violating that order. I have to be given 10 days notice of that. Then we go have a hearing. And at that hearing, a court can order me to jail. They can do that. But by that time, we're talking, it's 2 weeks later. And people can be hurt by then. The protective order is a weird civil court order because it's enforceable. It's criminally enforceable. So if I have a protective order that says, if you have a protective order against me that says I can't come within 200 yards of you, and I come within 200 yards of you and you call the police, I'll be arrested for that. So that's the big difference. All right, so this is the question the woman over here had earlier. who is entitled to protection? This is how family and household is defined in the Family Code. It's under Title IV, Chapter 71, that gives us the definitions of who is a family. So if my next door neighbor says, Gina Longwoods, I am going to kill you, can I get a protective order against my next door neighbor? Well, the answer to that is no, unless one of these things is true. So if we're related by blood or marriage, so if my next door neighbor is my brother-in-law, I can get a protective order. If we currently live together or have ever lived together, so if I used to be in a relationship with my neighbor and we lived together at some point, then I can get a protective order. Foster parent, foster child relationship, you can get a protective order. Yes?
Just want to clarify that living together means roommates as well.
We've done it UT dorm, people living together in a dorm. So it doesn't have to be a romantic relationship necessarily. If you're currently in a dating relationship or have had a dating relationship in the past, so if I used to date my next door neighbor, then I could get a protective order. Now, another nerdy thing is you can now read in the Family Code the definition of dating. So you can find out whether you're just friends or whether you're more than that by reading your Family Code. All right. And this is the one that I had to diagram out that didn't make much sense to me. If the applicant is dating or married to someone who was married to or dating the respondent. So let's say I'm dating Bill, and Bill and I break up. And Bill starts dating Jane. And then I call Jane and I say, Jane, I'm going to kill you. Then Jane can get a protective order against me. Jane and I have never lived together. We've never been married. We aren't family. But I have threatened her, and she is with someone that I used to be with, right? So that's one of the newer relationships. And then maybe they don't know each other at all, but someone is a victim of stalking or a victim of sexual assault. They can also request a protective order. Interestingly, those protective orders aren't under the Family Code. They're under the Code of Criminal Procedure. But sometimes you have people in families, like we've done in our clinic before, sexual assault protective orders, even though the parties are married, for example. So you can do that. And the benefit of these is these protective orders are typically 2 years. There are exceptions to that, but most of the time you can just get a 2-year protective order. These can be lifetime. So you can sometimes get a much longer protective order. So if there has been stalking in the context of a marriage relationship or there has been sexual assault in that context, you can plead both in order to get the maximum protection if your client, feels like they need that. So where can a protective order be filed? Clients come in, I've screened them, they can get a protective order, they're scared, they want a protective order. Where can I file it? I can file it where my client resides, in the county where they reside. I can file it where the respondent resides. Sometimes your client has fled an abusive relationship, and let's say my client used to live here in Austin with the perpetrator, but she's moved now to Dallas but doesn't want him to know where she is. And she doesn't want to be filing in Dallas, so she might want to file here. If there's a divorce pending, you can file in the county where the divorce is filed. So maybe, I'm married here, we file for divorce here, there's an incident of violence, then I can, and I flee, but I can still file here even if neither of us live here anymore. Finally, you can file in the county where the violence occurred. So maybe the violence occurred at an exchange of the child in Waco. Then I can file for a protective order there. So you do have some options. How much does it cost? This doesn't mean how much are attorney's fees. Attorney's fees are whatever people charge for their fees. But the county, usually there are filing fees that are incurred. You don't have to file an affidavit of inability to pay costs to file for a protective order on behalf of someone, because the court cannot charge the clerk's office, they can't charge the applicant for filing for a protective order. Now, if a protective order is issued, the respondent shall be ordered to pay court costs unless there's a showing of good cause or indigency. One thing I'm not sure what the VLS orders look like. But one thing that's really important to our district clerks is that they get those fees. They want, to get those fees. And what they are is $174. I know the form, like the ProDoc form says $16. That's not how much it is. And they will, because they've told me, you need to put $174 in that blank. So that's just something to know. So, okay, my clients come in, I've screened them. They want a protective order. I've determined they meet the relationship requirements. To get a protective order, what do I do first? Well, the first thing I do is I prepare an application, and I am usually going to request a temporary ex parte protective order. Now, we had a case recently in our clinic. We didn't ask for an ex parte protective order, and the reason for that is she had a magistrate's order for emergency protection that went through the end of December, and we knew we were going to have a hearing on our protective order sooner than that. So we didn't worry about getting the ex parte protective order. You don't have to do it every time, but you'll do it most of the time. The benefit of that order is that you can obtain one without notice to the other party, because what might happen if you gave notice to the other party? Well, the other party might go do something really bad to my client before we can get to court with an order saying he can't come to the house. So that's why. I will say, in Travis County, if you're in the middle of a divorce and the other party is represented, you do need to notify that other lawyer that you're going to do that. You don't have to tell them days ahead of time. You could contact them that morning and say, just want you to know, I'm going over this afternoon to the uncontested docket to request that the court sign an ex parte protective order. But you do need to let them know. The court's going to want to know that you did that. The court has to determine by reading that application that there is a clear and present danger of family violence. So you're going to put in some details of what has happened. And once you get your ex parte order, it's good for up to 20 days. If you can't get the other person served with it, it can be extended for additional 20 days until you get them served. But it's going to be good for 20 days until you go back to court to get something done. Yes, Brittany?
Sorry, for notice for a temporary ex parte, or you have to notice the other attorney, not a pro se litigant, and where?
That's right.
Where is that rule? Or is it just?
I think there's a local rule that actually says that now. It used to just be that they would ask you, is the other party represented? Have you notified them? That they would ask me that, but now I think they actually have it. Shane, do you know?
Yeah, some judges like to make you file an affidavit as a lawyer stating where another lawyer on your side.
That's probably a good practice, one that I don't do. But. Yeah.
Sorry, really quickly, there's a presumption that that attorney's not getting it. It's just safety concerns to me, right?
That's why I don't give long periods. It's pretty short.
Okay.
We can talk more about that, but yeah. I'm not going to give enough time for a lot to happen between those times. Let's see, where are we? So, what does the applicant have to prove? So now we have our temporary ex parte protective order. We set our hearing. What do we have to prove? Most of the cases you'll see, this is going to be what you have to prove. It's going to be the client's first protective order against the opposing party. And if that's the case, you have to prove two things. You have to prove that family violence occurred. How do you prove that? What is family violence? Well, family violence is defined. There's a long definition in the paper and in the statute. The short version is, was there physical pain or was there a threat of physical pain? That's the very short Gina Lundquist's version of that. So if your client was slapped, if they were pushed and it hurt, that sort of thing, then that would be pain or threat to cause pain. Family violence is likely to occur again. A lot of people say, how do you prove? How do we know what's going to happen in the future? The best way to do that, there are two things that help you prove that. The first thing is to file as soon as you can after the last incident. If you wait a really long time, then a judge could say, well, it hadn't happened in 6 months. What makes you think it's going to happen again? You may get that. So you want to file soon after the last incident. The other thing is to show a pattern. Maybe this wasn't the first time, or maybe last time it was just kind of a shove, or somebody making somebody get out of the car, and walk home, or something like that. Show that there's this controlling pattern. And a lot of people think, well, I don't have any police reports, I don't have any medical records. if your client's credible and can take the stand, sometimes all you got is your client, because domestic violence doesn't usually happen in front of a big crowd. I mean, when it does, I consider that lucky. But usually it's going to happen behind closed doors, where nobody can see it. And so if your client's credible, don't be afraid to go forward on those. If the client has had a prior protective order, and one of the criminally enforceable provisions, and I'm going to tell you which ones those are in just a second, was violated while that order was in effect, then you can automatically get a new protective order. You don't have to show new violence. You just have to show, it might be the 200-yard stay away that came within 200 yards. We had a case recently where there was communication in a threatening or harassing manner, repeated text messages. Social media has really changed this practice altogether. And so people say things you just can't believe they say in a text message that can be screenshotted and sent to a lawyer. So if one of those provisions was violated, then all you have to show is there was an order in place and it was violated. Doesn't mean, they might not have called the police at all. But if you can show, here's the provision and here's the violation, then you can get a new protective order. There's also another way, if you have a prior protective order that has expired or will expire in the next 30 days, and there's been a threat of harm that reasonably places the applicant in fear, you can request another one. Now, I don't know how this wouldn't automatically fall under the last way. Sometimes I'll plead them both, just belts and suspenders, but you know, if somebody says, you just wait till this protective order expires, that might be enough to show, here's your protective order, it's about to expire, it has recently expired, and there's been some sort of threat of harm that makes that person afraid that something bad's going to happen when it does expire. So what can it do? Well, there are the criminally enforceable provisions. These are the parts that if any of these things happen, the person can be immediately arrested. So prohibiting family violence, prohibiting threatening, harassing communication, both direct and indirect. So, you know, it could be that the respondent isn't calling your client directly, but he's having his mama call your client and having his mama pass messages along. It can prohibit going within a certain distance of where the applicant or the children live, work, go to school, or in daycare. We talked before about how it's okay to omit the addresses. It can prohibit stalking behavior, possession of a firearm, and now the newest thing it can do is it can protect pets too. One thing that we've learned about people who are abusive to their partners, they're often abusive to their children and their pets. And so that has been added. So they're also civilly enforceable. These are the ones where you as a lawyer can file a motion for enforcement, give them notice, have a hearing. And these are the things like prohibiting someone from removing a child or pet from possession. Now we learned this is also a crime, at least the child part. For interference with child custody, that's a crime all in itself. But it's also enforceable through civil contempt. It can set up visitation with the children. So oftentimes, anybody talk about Planet Safe or any of the visitation centers?
They have not yet.
Okay. Well, there are places where that can be ordered, that the exchanges of the child occur supervised by somebody else, so the parents don't have to see each other. But they can also supervise visits in cases where there's some concern about the perpetrator being with the children. It can prohibit transfers of property. It's kind of like a restraining order type stuff. It can order, as Catherine talked about, child support, spousal support. It can require attendance at a batterers intervention program, that sort of thing. There's also a catch-all provision, that's number 8 down there. If there's something particular your client wants that's not on the list of things that's in the statute, there's also a catch-all that just says any other requirements that will prevent family violence. So if there's something else that they think is really important, pitch it, you know, try to get it, put it in your order and see if it works. So how long does it last? That ex parte protective order is only going to be good for 20 days. You're going to set a hearing and actually give notice and let the other side tell their story at that hearing. If it's a final protective order, it's good for up to 2 years, but it can be longer. It can be up to permanent. It can be any duration. If there was stalking, sexual assault, serious bodily injury, or the person has had 2 previous protective orders and violated those orders. And the court can then just put the onus on the perpetrator to come back and get it vacated, as opposed to keep having the victim come in every 2 years. If the respondent is incarcerated for any reason on the date the protective order expires, this is actually old. As of September, it changed slightly. If they're incarcerated on the date of expiration of the protective order, and it can be for anything, it doesn't have to be for family violence. It could be that they got a DWI the night before and they're in jail. Or if the protective order expires within a year of the date the respondent was released from jail, then it is automatically extended for 1 year after the release. If they've been confined for 5 years, and for 2 years if they've been confined for 5 years or less. You just have to read the statute to figure that out. But the bottom line is, if your client comes in and they have a protective order that's expired, but in conversation with them, you learn that the person was incarcerated on the date it expired, you can go in and request the court actually sign a new one, because it's very confusing for law enforcement. It's going to look expired. If they call the police on that protective order, police are going to go, well, this expired 2 years ago, but wait, they were incarcerated and blah, blah, blah. You can actually get a new order signed if that happens. All right, so what happens if it's violated? If it's one of the criminally enforceable provisions, it's a Class A misdemeanor, so they can get up to 1 year in jail, up to a $4,000 fine. If it's one of the civilly enforceable provisions, then it's contempt, like we talked about before. Up to 6 months per violation, up to a $500 fine per violation, or both. So can a protective order be modified? Yes, a court can at the request of either party. If they want it changed, you can go in, you can ask for it, and it's up to a judge whether they modify it. Are protective orders issued in other states enforceable in Texas? This is part of the Violence Against Women Act that passed, I don't know, kind of a long time ago now. But that's the section. Also, the Family Code has a mirroring provision for that. Oops. Are protective orders from other states enforceable? For Texas, enforceable in other states. Texas orders, somebody going somewhere else, the answer is yes. I always encourage people, when you get where you're going, contact law enforcement, make sure they have it on file there, so that they have that information. Mutual protective orders, it used to be years ago that when you would show up, I'd file an application for protective order, I'd show up with my client for that. Then the other side would get in front of the judge and say, Judge, we don't care if there's a protective order, if you'll issue one against them too. And the judge often would, or they would ask for one, and my client would go, well, sure, I'll agree to that. Well, there were problems with that, and the biggest problem is enforcement. When the police come, they would arrest both people, or they would arrest nobody, and it just didn't work. And so now, the applicant and respondent may agree to do or refrain from doing those civilly enforceable things, but the criminally enforceable things, the only way for those to be issued against someone who has applied for a protective order is if the other side has also applied, like filled out the paperwork, filed the application for a protective order. You can't even agree your way out of that. All right, that is all I'm going to say about protective orders. I've said a lot about protective orders. I want to spend just a few minutes on some of the other statutes that will come into play. Obviously, if people are married, then a divorce is a legal option on the list. If they have children together, whether they're married or not, the suit affecting the parent-child relationship, or the custody suit, is an option. A couple of things to note: you may have a case where you don't have very good protective order evidence. Maybe it doesn't seem like a very good protective order case. Then certainly you can still request a restraining order if there's something outside of the standing order that you think you need to help keep your client safe, like a stay away, 200 yards stay away. I mean, that may be better than nothing, so you can request a restraining order. Also, if there is community property to be divided and there's been family violence, then you can, as Katie was talking about, you can file a divorce on the grounds of cruelty and request a bigger piece of the community pie. Spousal maintenance. In order to get spousal maintenance, typically you have to be married 10 years. However, it doesn't matter how long you've been married if the other person has been convicted or received deferred adjudication for family violence. You might have been married 3 years. If that is true, you can request that the court order spousal maintenance. So that's a reason to bring it up in a case where you might not otherwise bring it up. Also, objection to mediation. The local rules require if you set a case longer than 3 hours or you set a case for a jury trial, you're required to mediate before you go to court. We could do a whole class on why mediation isn't always appropriate in domestic violence cases. And there's some people in the camp that you should never, ever, ever mediate a domestic violence case. There's some people in the camp that shouldn't matter at all. I'm somewhere in the middle. I usually leave it to my clients. We can object to it if we want to, but they don't have to. Some people really are hoping to resolve their case outside of court, so you certainly can do that. But you have a right to object. So the state law would trump the local rule here. And if once you file an objection to mediation, the court cannot order you to, you don't have to mediate unless the other side sets a hearing to say, wait a second, yes you do. Yes, we are going to mediation. And if they do that, then the court would then have to make a determination about that. And if the court finds that they do want you to mediate, they can't make it be a face-to-face mediation. They have to put precautions in place. And I'm sorry if you hear my alarm going off. I was making sure I didn't talk too long here. Let me see if I can go off. All right. And then confidentiality of information. Katie talked about this too. If there's been a history of family violence and if it wouldn't be safe for the bad actor to have the information of the parent, the address and all that of the parent, the court can order that be kept confidential. And again, you want to plead that. That's something you want to plead. And then finally, let's say your custody order is in place, and then after that order is in place, there's an assault that leads to a conviction or deferred adjudication for that assault. That is a basis in the Family Code for modifying possession and access and conservatorship. So that's something to be aware of. I want to talk a little bit more, very briefly, about custody issues. One of the most important sections of the Family Code in my office is 153.004, and it sets up some really, I would say clear, but they aren't clear, some standards for what courts are to do about conservatorship and possession and access when there's been a history of family violence. So as far as conservatorship is concerned, the court has to consider family violence occurring within the last 2 years from the date the suit was filed or while the suit is pending, and looking at conservatorship. Does that mean the court can't look further back than 2 years? No, that's not what that means. But it means they have to look back at least 2 years. The court cannot order joint managing conservators if you can show that there's a history or pattern of family violence, and there's a rebuttable presumption that the parent who committed family violence should not be appointed the sole managing conservator. Those were done piecemeal through the years. I think we'll see those cleaned up at some point. They tried to this year, but they tried to this year and they didn't. So that's conservatorship. The possession and access schedule. The court has to consider violence in determining whether to restrict possession of a child. So whether to order that the person not have access or whether they have supervised access. The court may not allow any access to a child if there's a history or pattern of domestic violence during the 2 years preceding the date the suit was filed or while it was pending, unless the court makes special findings. There are these special findings that have to be made. It is rare for a court to order no access to children. That is a rare occurrence. It happens short of termination, where there's a higher burden of proof. It is rare, but it does happen sometimes. You may have a case where it's appropriate. We've had a few, but that's what the statute says, no access unless there's certain findings. There's a rebuttable presumption that it is not in the best interest of a child for a violent parent to have unsupervised access. So there's a presumption that you should have supervised visits at a minimum. So that's what I'm going to say about custody. I want to just mention briefly personal injury lawsuits. These are available. Just like if somebody hits you with their car, if somebody hits you with their hand, you can sue them. We've had some success in our clinic doing some personal injury lawsuits, so you can plead those in your divorce. That's possible. I think it's really important to let clients know of that availability and make sure they understand the statute of limitations, because it's, for most kinds of personal injury, it's 2 years. So you want to make sure they're aware of that. They don't miss a deadline there. But these are the kinds of lawsuits that that have been successful pursuant to case law. So just be aware of that. And then another legal option, if you have a client who is not documented, they may be able to get their papers by self-petitioning for their legal status. And that the Violence Against Women Act, again, is the other thing it did. It's only federal law really talked about, other than that firearms legislation, is it allows protective orders to be enforceable anywhere. It was always my position. We have full faith and credit of the U.S. Constitution. It should have been true anyway, but we had to say it out loud in a federal statute. Finally, every once in a while, you'll have a client who has tried to moved away, and every time she moves, her batterer finds her, and every time she moves, her batterer finds her, and every time she moves, her batterer finds her. There are some people who just need to disappear. And so one of the things that we have done in our clinic is we do a name change. We did this just last week with somebody. We got their name changed. We sealed the record, so it was not a public record, after we had gotten like 15 certified copies. Sealed the record, and then went to the Social Security office and had her Social Security number changed, so that she is essentially taking on a new identity. Not many people want to do this, but it is something that can be done. And then finally, if the opposing party is on some kind of paper, if they are on parole or on probation, there are going to be conditions of that they have to do. They have to abide by. Things like pay child support is usually in there. Things like not have contact with the victim. So if those things happen, you can assist in advocating for their revocation of their probation or parole if your client is interested in that. I'd always ask the client first, because a lot of clients are like, no, he's working, I'm getting child support, I don't want to do that. But it is a legal option in our list of options. And that is it. The contact information for me is on the front of the paper. You can call or email with questions. I want to thank you again for volunteering and wish you happy holidays.
I thank everybody. Please pick up your trash and so on and throw it out on your way out. The building has asked that people wait till 5:15. I realize that so it's going to be a little bit difficult, but they don't want to cause a traffic jam for the tenants of the building.